Hello, welcome to the Constitution Study. My name is Paul Engel. I am glad you could be here today. If you are a first-time listener or if you're a returning listener, I'm glad you could come. I'm glad you could put the time, the effort into learning about our Constitution. We are striving to return the Constitution to we the people. That really is the only way that we can remain free. I hope you'll head over to the constitutionstudy.com. You can find more about this particular episode. You can find out how to sign up for the mailing list. Sign up for that list and you will get free access to my current essay, How the 16th and 17th Amendment Destroyed the Republic. You can also support the Constitution Study by going to patreon.com/Constitution Study. There is a link on the website for that. I also hope you consider subscribing through Apple Podcasts. We're looking at the numbers, and it's still early. We're still getting started, but I look forward to seeing more and more people subscribing and downloading these episodes as they become available. So on to today's episode. Today, I want to discuss a little talked about Supreme Court opinion that is extremely important, not simply for what it says, but for what it doesn't say. And it deals with a part of the Constitution most people haven't heard about, what's called the Contracts Clause. Article 1, Section 10, Paragraph 1 of the Constitution says, among other things, no state shall pass any ex post facto law or law impairing the obligation of contracts. Now, it seems pretty simple, right? No state can pass any law that's ex post facto, after the fact, or a law that impairs the obligation of contracts. But if there's one thing I've learned over the years, there is nothing like the judicial system to turn plain, simple language into putty. The Supreme Court case I'm talking about is Sveen et al. Versus Melin. I believe I'm pronouncing those correctly. And in this case, this particular case, our high priest in black robes took a very simple idea that states are not allowed to pass laws after the fact or impairing and preventing the obligations of contracts, and they turned it completely on its head. So reading from the opinion, which I will put links to the opinion in the episode notes, but it says, held, the retroactive application of Minnesota's statute does not violate the Contracts Clause. The clause restricts power of states to disrupt contractual agreements, but does not prohibit all laws affecting pre-existing contracts. Now, in this case, let me give you a little background. Mark Sveen and Kay Melin divorced in 2007. The state of Minnesota effectively changed the contract for the life insurance policy Mr. Sveen entered into back in 1998 by removing Ms. Melin as a primary beneficiary. Melin claimed that because the law did not exist when the policy was purchased, and she was named the primary beneficiary, applying the later enacted law to the policy violates the Constitution's Contracts Clause. Actually, to me, it's the ex post facto clause, but that's part of where things start becoming problematic. See, in other words, by applying Minnesota's law to a contract entered into before the law went into effect, it was in effect an ex post facto application of the law and effectively nullifies the insurance policy contract. I suppose the argument could be made that if the law went into effect before the divorce, then it was not retroactive to the divorce, but I haven't seen anybody make that statement in the decision. Now, while the question of, retroactivity and the retroactive nature of the law may be technically defensible in certain circumstances, the part of the law that changes the beneficiary of a life insurance policy or any other contract is a clear violation of the Contracts Clause, and this is the part that's being missed, at least by most people. See, the Constitution doesn't say a state may impair the obligations of contracts under certain conditions, and it doesn't say states shouldn't impair contracts. Instead, it specifically, explicitly forbids states from creating laws that impair the obligations of contracts. So how, with such clear and simple language, can the state of Minnesota, or any court, much less the Supreme Court, get this so wrong? They do it by thinking they know what people should want better than they do. Reading from the opinion, the legal system has long used default rules to resolve estate litigation in a way that conforms to descendants' presumed intent. Here's red flag number one. Problem number one. How arrogant must the legal system be? How arrogant can the court system be to presume they know the mind and intent of anyone without any documentary proof? Sure, if someone dies without a will or without instructions, the court must determine what to do with the estate. And to that end, the passing of laws which specify default rules should a decedent not leave legal instructions, it kind of makes sense. Now, even if a will is in place, since it's not a contract, state laws nullifying said will upon the divorce of a couple could be defensible constitutionally. Personally, I think it's a huge heap of junk because it assumes that the state knows better than the people what the people want to do. And it is a ginormous leap to assume that the state or the court knows better than the explicit instructions of the decedent. This isn't resolving estate litigation, but the tyranny of an all-knowing state. See, if Mr. Sveen wanted to remove Ms. Melin from his life insurance policy, he had more than enough time to do so. Neither the state of Minnesota nor the children who were declared Mr. Sveen's beneficiaries by state dictate could use the excuse that he wanted to make the change, but he didn't do so because he had 4 years to do it. He had 4 years between his divorce and his death when he could have made that change. He decided not to. Reading further from the opinion, this is from the synopsis. The Contracts Clause restricts the power of states to disrupt contractual agreements, but it does not prohibit all laws affecting pre-existing contracts. The two-step test for determining when such a law crosses a constitutional line first asks whether the state law has, quote, operated as a substantial impairment of a contractual relationship. Continue on, the court stops after the first step here because three aspects of Minnesota's law taken together show that the law does not substantially impair pre-existing contractual arrangements. Here's problem number two. The Supreme Court is intentionally, effectively rewriting the Constitution. You see, according to the Supreme Court, to determine if a law violates the Contracts Clause, they must first ask whether the law has operated as a substantial impairment of the contractual relationship. Their own words. However, the plain language of the Constitution says, no state shall pass a law impairing the obligation of contracts. The constitutional standard is not the amount of impairment to the contract, but whether any impairment to its obligations would exist. Clearly, changing the beneficiary of an insurance contract impairs the contract. Mr. Sveen legally entered into a contract with an insurance company. The terms and the conditions stating that in the event of his death while the contract was still in force, the primary beneficiary was to be Ms. Melin. However, the state of Minnesota, presuming to know what Mr. Sveen wanted better than the documentary proof of the contract itself, changed the contract to remove Ms. Melin as a primary beneficiary. I'm having a hard time thinking of a better example of a state law impairing the obligations of a contract. You know, the idea of laws changing insurance beneficiaries upon divorce, I did a little research and it appears to be based on what's called the Uniform Probate Code. If you've ever acted as an executor for a will, you know all about probate courts. See, the Probate Code is a creation of the National Conference of Commissioners on the Uniform State Laws. Apparently, there's a commission of people that are trying to make sure that state laws are uniform. And part of this code includes a provision that invalidates wills upon certain major life events, such as marriage, childbirth, and divorce. Again, I think that the state has no business being involved in that, but at least I don't, at this point, see a constitutional issue there. However, in 1990, a revision was made, and quoting from the Uniform Code, page 25, It says, quote, the revocation upon divorce provision, section 2-804, was substantially revised so that divorce not only revokes testamentary devices, but also non-probate beneficiary designations in favor of the former spouse. Close quote, back to real English. In other words, the states thought it necessary to revise their laws so that divorce not only revoked wills, the quote-unquote testamentary devices, but also other items, including contract items such as life insurance and retirement plan beneficiaries. While some may debate the logic of state revocation of designated beneficiary benefits after a divorce, I personally think it's tyrannical, and it's a perfect example of government telling the people how they should live their lives and how they should change their legal documents. There's still the problem of the U.S. Constitution, though. The Constitution specifically forbids states from writing laws that change or impair the obligations of a contract. This travesty of justice was compounded by multiple courts, not just the Supreme Court. The court substituted their judgment for the black and white letter of the Constitution they swore to uphold. Even under the court's own standard of quote-unquote substantially impaired, this doesn't even come close to passing the smell test. If I have a contract that says you are to pay one person and you change it to pay another, that is a significant change to the contract. According to the court, if Mr. Sveen did not like the modification the state of Minnesota made to his contract, he could always go back and change it. Why in heaven's name should Mr. Sveen have to undo an unconstitutional change to his legally binding contract? Why would anyone even consider that the state would modify a contract without their knowledge? We've all heard that ignorance of the law is no excuse, but the supreme law of the land says Minnesota cannot change a contract. Period. Full stop. No arguments or debates. It's over and done with, yet it was. And while the travesty of this law being allowed to be to remain in place and laws like it across the country, I mean, it's just illogical. And it's just stupid stuff like this I'm kind of used to from the court. But probably the most arguable problem with this ruling is that out of 9 justices, only one, Justice Gorsuch, disagreed with the decision. But apparently even he cannot read the plain language of the contracts clause. Quoting from his dissent, the court's argument proceeds this way. Because people are inattentive to their life insurance beneficiaries designations when they divorce, the legislature needs to change those designations retroactively to ensure they aren't misdirected. But because those same people are simultaneously attentive to beneficiary designations, not to mention the legislature's activity, they will surely undo the change if they don't like it. And even if that weren't true, it would hardly matter. People know existing divorce laws sometimes allow courts to reform insurance contracts. So people should know a legislature might enact new laws upending insurance contracts at divorce. For these reasons, a statute rewriting the most important term of a life insurance policy, who gets paid, somehow doesn't substantially impair the contract, just, quote, makes a significant change. Mr. Gorsuch goes on, respectfully, I cannot agree. Minnesota's statute automatically alters life insurance policies upon divorce to remove a former spouse as beneficiary. Everyone agrees that the law is valid when applied prospectively to policies purchased after the statute's enactment. But Minnesota wants to apply its law retroactively to policies purchased before the statute's adoption. Justice Gorsuch's issue with the opinion appears not that Minnesota law substantially changes, therefore impairs the contract for life insurance, but that it does so retroactively, or ex post facto. While documenting the fallacy that the state must step in because during a divorce, those involved may be inattentive to the beneficiaries of their life insurance policies, while at the same time expecting them to be attentive to the change made by the state, he goes on to state that the problem isn't with the change in the contract, but the fact that Minnesota wants to apply this law retroactively to policies purchased before the statute's adoption. He says, quote, everyone agrees that the law is valid when applied prospectively to policies purchased after the statute's enactment. Mr. Gorsuch, everyone in the legal system may agree, but the Constitution absolutely does not. It clearly states that no state may pass a law that impairs the obligation of contracts. It does not say states cannot impair contracts except for major life changes, because the state presumes to know how people should change those contracts, or even because 9 people in black robes say so. By your own words, you admit that this law rewrites, quote, the most important term of a life insurance policy: who gets paid. How can that be and not be an impairment of the contract? By your own words, if the court had decided the way you prefer, they would have condoned the blatant violation of the Constitution. Actually, they continue to condone the blatant violation of the Constitution, the destruction of the sanctity of contracts, and secured the supplanting of a person's wishes with that of the state in legal precedent. Well, as yet another example of why courts were never intended to be the arbiters of what is constitutional, the real damage this decision does is to effectively nullify the Contracts Clause of the Constitution. By allowing states to rewrite laws that change contracts between other parties, contract law in the U.S. becomes a plaything of courts and legislatures. From now on, you cannot rely on the words of the contract you signed to be legally binding. And all it takes is a state legislature to write a law that changes the contract, and those carefully crafted words are meaningless. And the Supreme Court, rather than protecting your rights to have a secure contract, simply rubber stamped the state's desire to tell you what you should do with your contract. Worse than the change in the contract law is the damage its opinion does to the republic itself. If the court, through issuing an opinion, can effectively change the meaning of the plain language of the Constitution, we no longer live in a republic. We live in a banana republic, ruled by an oligarchy of 9 justices in Washington. As you may be able to tell, I'm a little wound up about this because it's one of those itty-bitty things that nobody talks about, but is so important. It shows such a change, not only in how we treat the Constitution, but how we treat the black letter law of our nation. So maybe you'd be asking, what can we do to reverse this, and I call it a travesty of justice, an attack on our Constitution? Well, first, contact your state legislatures. I understand that many states have very similar laws because it was created out of attempt to have uniform probate laws. Show them just how this is a blatant violation of the Constitution. If they refuse to act, tell them you will work to remove them, since the oath they took upon taking office includes supporting and defending the constitutions of the United States and their state. If they will not uphold their oath, they are unfit to serve in the legislature. Make sure your state legislators know that you will not stand for them supporting such an illegal and unconstitutional law, and will work against them in the next campaign and in support of someone who takes their oath seriously. Most drastically, we should all contact our representatives in Congress. While I'm sure they will be very much opposed to the idea, they should file articles of impeachment against those who decided in favor of the Minnesota law over the Constitution. Subverting the Constitution, along with the prescribed method of changing it, is clearly not good behavior, and therefore, according to Article 3, Section 1, grounds for them to be removed from office. See, judges don't have lifetime appointments. Quote, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. That is the United States Constitution, Article 3, Section 1, black letter law, supreme law of the land. While those in Congress are loath to do so, we must demand that they fulfill all of their duties, including the ones to keep the executive and judicial branches in check. If our elected representatives will not uphold their duties to keep the other branches accountable, then it is high time they be removed, preferably by the ballot box. See, few seem to have recognized this infringement on their rights, and even fewer seem to know how to defend them. The Supreme Court is not our supreme ruler. No matter what they say, it is the Constitution that is the supreme law of the land, not the Supreme Court. This is yet another example of why we must return the Constitution to we the people if we are to live free. And I'll bet you very few, if any of you, heard anything about this opinion being released on the mainstream media. As you can tell, I am kind of fired up. Like I said, it's one of those hidden attacks. Most people, if they even hear about it, will probably brush it off, not think much about it. But it is an attack on the basic foundation of our Constitution. I hope you learned something today. I hope you learned about the contracts clause. I hope you'll take the time and look at the documents in the show notes. I'll have links to the ruling and probably the uniform code for probate code and some others. I hope you find it. Please sign up for the newsletter. Sign up for the mailing list, I should say. Keep informed with what's going on. Consider supporting me through Patreon. I'm trying to get this really up and running just so I can dedicate some more time to it, because I think it's important. I truly think that our liberties and our freedoms are being taken away, and in many ways we're giving them away, and it's things like that that make this happen. So I hope you enjoyed it. I hope you found it worthwhile, and I hope to see you again on the Constitution Study.